Good afternoon, everyone, and welcome to this month's England and Wales Property Forum. I do apologise for the late notice change of date for this forum today. It does look, however, that we have even more people attending today, which is rather good news. As well as these sessions, we do offer in-house training for law firms, and we will be sending details out to all in a mail shot this week. Do ask either myself or Robert Kelly any questions you may have. This is your forum where you get to control the direction of conversation and debate. Please use the chat bar to ask any questions or put your hand up and I'll give you access to the microphone. I'll hand over to Ian now to tell you all the things that he's been up to, any guest speakers today, and he will commence proceedings. Thank you, Ian.
Thank you much, Freddie. Good afternoon, everyone, and welcome on this cold Monday afternoon. It's cold up north at the moment, so thank you very much indeed for coming along. Yes, apologise for last week, some technical issues, etc., which I'm quite happy to take the blame for. I get the blame for everything else, so why not get the blame for that? But thanks for coming along today, and thanks, Freddie, for introducing me. I'm delighted that I've got James from Main Solutions, who's going to be joining us for a little while this afternoon, telling us about some work that he does in connection with product concerning drainage issues. Again, something close to my heart, given the fact that we have at home septic tanks, private water supplies, and probably more than enough problems and issues for James to have a look at if he had a spare minute. But he's going to share with us his work and the work that his organisation does, that I think will be really useful. But as Freddie says, this is your event, and we're here to talk about your topics. So I've got a number of topics that I want to share with you, including issues associated with the revised TA6, some yet more work I've been doing and some scary work I've been doing with regard to the Building Safety Act that I want to share with you. Talk a little bit about the protocols in connection with exchanging contracts that the Law Society is proposing, some news on the Law Society guidance and climate change, and one or two other things as well. If you have any burning issues that you'd like us to explore, please do so by putting the topic in the chat column that you can access at the top of your screen, and we'll endeavour to cover those issues before we finish. Useful websites I've put on the slide there that I'd like you to have a look at. In particular, I've been looking recently at the Leasehold Advisory Service website, and I've been doing some work with the Leasehold Advisory Service. Some interesting things on there with regard to service charge and some of the recent decisions of the First Tier Tribunal in connection with the BSA. So that's all worth a look at. But before we do any of that, I'm delighted to introduce to you James of Main Solutions. And James, thank you for coming along and giving up your time today. And I think before we embark on a chat, and again, if you have any questions of James, please use the chat facility and we'll try and deal with them before we finish. But before we do that, James, I think you've got some slides to run through. I think, James, you're happy that I will act as your sort of prompter with regard to movement of the slides. I'll endeavour to do as requested. All you've got to do is shout and I'll move them along for you. But James, welcome. Thank you very much for joining the forum. And if you would just explain a little bit about what you do, a little bit about how you can help resi conveyancers and some of the issues that you've encountered with regard to your work. So over to you, James.
Lovely, thank you very much, and thanks for having me. And it's very warm down here in Berkshire, so I feel a little guilty that you're chilly, but hey ho. So I'm James. I'm the managing director of Main Solutions. I've had the pleasure, and I'm not saying that sarcastically, I've had the pleasure of being in the drainage industry for nearly 30 years. For whatever reason, I absolutely love it. I like to think I'm good to it. It's certainly been pretty good to me. And today is really about my specialist subject, if I can call it that, of the off-mains, lesser known private drainage, off-grid. It all means the same thing. Talking about different drainage systems that are not connected to the main sewerage system and the issues they can create sometimes in a property transaction. So if you could whack the presentation deck on one slide for these are just some stats. I hate death by PowerPoint, but I think it's really impactful to see some of the numbers. The top one there, 4% of housing stock, that's from the Office National Statistics. That's not my data. And it actually flips it round. It only publicises that 96% of UK stock is connected to the main sewerage system. So in default, that gives us our 4%. And it works out to about 1,050,000 properties throughout the UK that have got their own private off-mains drainage systems. And then the other stats on this slide are purely in-house, but considering the vast majority of the services we provide are surveys for the purchaser or the vendor, then hopefully you'll see that our stats are meaningful and should resonate a little with you, I hope. So yeah, the absolute vast majority of the surveys are commissioned by the purchasers or potential purchasers, with only 5% of the vendors actually paying for that. My opinion on it is irrelevant. That's just the stat. If I was allowed an opinion, I'd say it's probably for the vendor. If I was selling my house, I'd want to make sure that I'm selling it with a full information sheet on what was there, what the condition was, etc., etc. A major issue which really doesn't get any press, and I know it's not sexy at all, but the 35% of properties looked at have cross connections. If any stormwater or rainwater is connected into a private drainage system, whether it be a septic tank, a sewage treatment plant, or a cesspit, it has massive detrimental effects on them. So whenever there are cross connections, all the regulations state they must be taken off. And sometimes the work to divert these off the foul system is almost as much as installing a brand new system itself. And then you've got to find a place for quite a lot of rainwater to disperse, which should be some sort of soakaway, bespoke soakaway, perhaps in a garden area. Of the surveys we carried out, a massive 60% of systems need replacement, and we're going to go on to what those different reasons for replacement are. But when you're looking at an average price of £15,000, it can cause an issue, especially if we're introduced to a property transaction too close. I say too close, quite close to completion. And in addition to the 60% that need replacement, an additional 30% need some sort of work, whether that's minor, manhole covers need replacing, gully replacement, some pipe work, repairs or replacement. But yeah, so on the flip side, only 10% of surveys come back with a report saying it's a completely okay system, no remedial works, no associated costs. So it's quite a big number, but they are the figures. If I go to the next slide, please, Ian, if you'd be so kind. So what we have found, specifically in England, where the general binding rules have they stipulate that a non-compliant system, if discovered during a property transaction, should form part of the condition of sale, but it doesn't then go to the next stage of saying how that works out from a physical works or cost apportionment perspective. So what we've seen is what you're now looking at on the screen, whether there's a straight negotiation for the full value of what the work is needed. Sometimes it's a 50-50 apportionment split between the vendor and the purchaser. Very occasionally, but it does happen, the seller likes to bite the bullet, no reduction in sale price, and they get the works carried out themselves. And sometimes the monies are retained in the client fund by the solicitor. And unfortunately, where we are introduced too late and we find an issue, sometimes it certainly causes a delay, but we have seen quite a few property transactions completely come to a stop and collapse because of it. So whenever I have the opportunity, like I say, very grateful for a few minutes with yourselves today, whenever I have the opportunity to speak to property professionals, it doesn't matter whether it's through my company or one of the other myriad of companies that do surveys on these systems, it's trying to introduce the mindset of carrying out a survey as soon as possible in that transaction process. Just in case there is an issue, we've got the maximum amount of time to sort it out, whether it's physically replaced, repaired, an apportionment, more quotes are obtained, whatever it might be, it's going to need a little bit of time. So as early as possible to get the survey carried out would be best. Go to the next slide, please, Ian. Thank you. The general binding rules, specifically again in England, we work UK-wide, but the majority of these systems are in England. And in 2015, when the regulatory reform called the Small Sewage Discharge General Binding Rules came into effect on the 1st of January 2015, it was predominantly because there were so many septic tanks discharging directly to surface waters, whether that be a river, a stream, ditch, etc. But it also served as a reminder of the other overarching standards and rules that apply to these private systems. And when we go out, yes, we're looking for compliance with these rules, but also want to make sure that it's a working system, that it's watertight, that it's functional, that it's not polluting. So there's a variety of checks carried out on site, and these are the reasons in front of us now that a system might need complete replacement. And the biggest hitter is the very reason the reform was introduced in the first place, which is septic tanks discharging to the ditch, stream, river. Sometimes they might be discharging adequately and compliantly to ground, some sort of drainage field or other dispersal system, which is perfectly allowable. But if the tank or sewage treatment plant is damaged beyond repair, it's immediately classed as non-functional, which in default, again, means it's non-compliant. Sometimes you've got a septic tank going to a soakaway. The soakaway's failed. There's nothing wrong with the septic tank, but because the septic tank now can only discharge compliantly to something called a drainage field, which is a series of perforated pipework, if there's insufficient room to put a drainage field in the garden, then that septic tank can't be utilised. So even though there's a perfectly good watertight asset there, if there's no room for a drainage field, it can't be reused. So then you're going for a brand new sewage treatment plant with some sort of bespoke dispersal method, and that's where the cost can go up. 15,000 is the average price to get a sewage treatment plant in the ground. That's not including the soakaway arrangement, which could be another 5 to 7 on top of that. So the costs quickly stack up. Another common problem, which we hadn't anticipated was going to be such a big problem, was when a property has extended the number of bedrooms and or put more properties on the original drainage system. If an asset is too small, it won't have time to work correctly. And that in itself, if it's only slightly undersized, it's not a big deal. But if it's massively undersized, the asset won't perform. It will lead to some sort of pollution situation. And in those extreme circumstances where they're horribly undersized, they should be replaced. But they are the reasons why. And they're coming up time and time again. Like I say, 60% of the properties we've surveyed need replacement. I can't speak for other firms that carry out the same activities, but even so, even if it's anywhere near that on a national basis, it just proves that these systems should be looked at and thoroughly and by a specialist. That's that slide done, Ian. Thank you. And I've rattled through that so quickly. Sorry. Normally I have 25 slides to go through. We wanted to be sort of punchy and impactful today. I'm the worst salesman in the world, but it's really just a case of all the things we do. We focus absolutely heavily on pre-purchase surveys because of the importance of the compliant aspect. We want to make sure it's not polluting. But any other items, any other services to do with off-mains drainage, we do. We work UK-wide. We do installations, surveys, testing of the ground for percolation reasons. Strangely, my world of drainage started at Norwich Union, which shows my age because obviously it's now Aviva. But I was in charge of insurance claims management for underground service claims. That's my claim to fame, although it's the weakest claim to fame ever. So that's also what we do: claims management. We work for insurance companies and loss adjusters, and we do lots of expert witness work. Typically on the back of disputes between neighbours and someone's putting a system in a field that they don't own anymore, and so on and so forth. They're always fun and games. But really, anything off mains would be delighted to help. But a third of what we do is purely advice. People are coming through on LinkedIn or email or picking up the phone, just asking questions. We're here to help in any way we can. So if you have any issues or concerns, please feel free to get in touch.
James, that's absolutely brilliant. Thank you so much. If anyone has any questions of James, feel free to use the chat facility. James, while we're waiting for some questions, 1 or 2 questions that come to mind. The first thing is, you've terrified me in that, as far as our property is concerned, I know that our septic tank percolates into a field, but I'm fairly confident no one has ever assessed the pipe work to see what it does or how it works. And we are on a slope, and we've got a major river that's 100 meters away. So I think anyone that would look at it would immediately say, hang on, there's an issue. We shouldn't be percolating into a field that's so proximate to a river, I guess.
Quite possibly, we'd obviously need to
Mm,
come out and have a look. But if it's
mm.
that far from the surface water, there's a very good chance that the ground will deal with any naughties, shall we say,
Right.
before it even
Yeah.
reaches it. If we're talking a few meters, you're absolutely right. It'd be going
Hmm.
in there almost at concentrate, and that would definitely be an issue. But with
Yeah.
100 meters,
Yeah.
technically you're complying, you're discharging to ground, and then you'd
Hmm.
need to test the water to see if any of the
Right.
suspended solids, any ammonia count was going into that watercourse.
Yeah. I had thought about building a sort of a pond and putting reeds in it, etc., as a buffer before the river, but we may be all right. But anyway, I digress. It's funny when you're mentioning that. I remember a guy, a lawyer, years ago, and he reckoned that Prince Charles, as he then was, is it Highgrove? Is it Highgrove? His house was it in Gloucestershire had the best grey rainwater management system that he'd ever seen. I don't know whether you were aware of that or you'd heard
No,
anything about it, but he used to reckon that the estate manager of Prince Charles, as he was, used to organise trips to have a look at this system. And I used to think to myself, well, I could think of a million and one things to do. And whilst it'd be very interesting to have a look at Highgrove or the estate, I'm not so sure I'd want to spend an afternoon looking at his
no, maybe not.
grey rainwater management system.
That's
On a
more
more
my thing.
serious note, James, indications as to cost. Can you get, and again, not to hold you to it because obviously it depends on the job, but
Yes.
where someone, if we go back to one of your slides, let's just have a look if we can. If we had an issue with regard to these sorts of things, sorry, not that, this sort of thing, yeah.
Yeah.
Um, to produce a survey, can you give us a sort of a spectrum of cost that someone could encounter?
Well, for the survey itself,
Yeah,
yeah, it's £600 plus VAT for a
yeah,
survey anywhere in the UK. And it produces a PDF report which is emailed within 2 working days after the visit, which says what the system is, where it is, if it's functioning, where is it discharged to, is the capacity adequate inside the asset?
yeah,
Is it watertight? Is it compliant? And then there are the cross connections issues, and if there are any costs, it will be fully quoted with a breakdown, a scope of works built into the report. So it's a holistic picture that's created 2 days after the visit.
right.
If the system needs to be emptied as well, that's an additional cost, and that's one cost we can't quote because regionally the costs are massively different. They can start
Right.
as low as £100. I think they can go
Hmm.
as high as £350, depending on where you are in the UK, which is why we only publish our cost, which we can control.
Yeah, and James, so you do the survey, there's a project that needs to be done. Do you offer a service where you'll sort of supervise the project? If it is a complete replacement or if it is a major exercise,
Definitely, yes.
again, again, I know from bitter experience, when people come in to do this work as contractors and you're sort of dealing with them directly, I can often see a sort of wry smile from the contractor on the basis that here's someone who hasn't a clue what we're doing and therefore we charge what we want. I
Yeah.
would assume that the service that you could offer would include that supervisory role, which I think would be cost effective on the basis that we're paying you, but you're managing the contractors that are doing the work.
Absolutely. So
Yeah.
over the last nearly 30 years, I've been very lucky in that I've worked directly and indirectly with so many firms, over 250 firms in
Right.
this sector, whether that be installation companies,
Hmm.
drilling companies, surveying companies. So at the moment, I've got a partner network of 110 companies in the UK. So
Right.
effectively, whatever the postcode, whatever the degree of complexity in, like I say, in any postcode, I'm very
Hmm.
fortunate that we have one, two, or three companies that can deal with that. And
Yeah.
yes, so any work that is quoted for through the survey inspection has the option to be fully
Right.
facilitated and managed through us, if the customer chooses to go down that route.
Brilliant. Brilliant. Thanks for that, James. And I'm noticing we've got hi Harriet. We've got a question from Harriet. Excuse me. And she asks, what do you do when there are a number of properties sharing a septic tank, which is now non-compliant with the rules, but no one can agree how to proceed or share costs? So we've probably got some that are saying, yeah, let's get it done, and one person resisting. Any sort of practical tips for that, or do the rules or regs make provision, James?
It's unbelievably common. Unbelievably common, and it's normally an inspection during a property transaction that is the catalyst for that.
Right.
Because it may be, I'll go back one stage and I will answer this, I promise. So many times we've heard that the customer said, we've got no issues, I can't believe we need a new system. And that's because, irrespective of how long they've been living at the property, they may have had a septic tank, they didn't know where it discharged to, but it's going to a free-flowing watercourse, and that's why they've never had a problem. But that is quintessentially a non-compliant, and you couldn't get any more non-compliant than that.
Yeah.
But in a situation where people don't think they've got an issue, obviously they don't then expect or want to receive a piece of information saying there's 4 properties shared. We want £5,000 each, please. We've just noticed it's non-compliant. They're not going to be happy, and it is extremely, extremely common. And it's not always people saying I don't want to be involved. Some people simply can't afford to be involved. So the only recourse currently available is if the environmental health team at the local authority are involved. They can serve a Section 59 notice under the 1984 Buildings Act, and then they give a specific amount of time for the issues to be resolved. And if they're not resolved, they carry the works out in default, and then recharge all the users on a equal apportionment basis. And for people that can't afford it, their apportionment will go against the house as a charge. So there is always a way around it, but that is the most extreme way.
Yeah. Okay. Harriet, I hope you got that.
Typically, it's information sharing.
Yeah. Yeah. Can you just remind Harriet? So it's Section 59 of the regs, or
So
Reg
it's
59.
1984 Buildings Act, Section 59. And it gives the local authority environmental health team the power to carry out the physical works and recharge the upstream users.
Right. Yeah. Okay. I suppose the other thing that could be done is, thinking about that as a sort of last resort, James, that if in a situation, if Harriet is acting for one of the cooperative homeowners who wants to do it, I suppose rather than going down that route, which is the sort of nuclear option, what you could say is, look, unless you cooperate, this is what we're going to do.
Absolutely.
And again, James, in that situation, instructing you, if say there's 4 homeowners who are cooperative, instructing you to explain why and the potential downside of not cooperating, in addition to you producing the report that would be appropriate, might be a way forward.
Yeah, and I normally find that when we're introduced, normally we're introduced very late into any proceedings, which is absolutely fine. I get that. That's because people have tried to resolve it themselves. I totally get that. It sometimes helps that we come in, we've got no agenda, we're completely impartial, and we're coming in and we haven't got the emotional ties that this has been going on for months or years beforehand. And we're coming in saying, well, here are the facts, here are your options, here are the approximate costs. Do you want to chat through how this works in the real world? And normally that gets a good response.
Yeah. Brilliant. James, Harriet's just said, amazing for your help there. Her problem's been going on for 4 years. So, James, thank you very much for that.
No problem at all.
And James, thank you again. I know you're so busy, really busy, and I much appreciate the time that you've spent. Does anyone else have any questions? James, you're more than welcome to stay with us for the remainder of the session, but thank you for your input. It is much appreciated. James, we'll have you, I think, coming along to our Scottish forum because it's been useful. Christopher Wright's saying thanks very much. He's really enjoyed it too. And James, we might organise a sort of webinar where we spend an hour looking at these things and going into in a little more detail. If you're up for that, that would be brilliant. Brilliant. And Zara Olabogus is saying hi, James, and saying hello as well. You know Zara, yeah?
She's my LinkedIn buddy. She's awesome. Yes.
Yes, she is
awesome.
awesome. Fantastic. Yeah. Brilliant. All right. Thanks, James.
Okay,
Fantastic.
take care.
Okay.
Thank
Thank
you.
you very much.
I know.
So, really interesting conversation from James. You've got his contact details, as I have. If you have any further questions, let me know. What I want to do now is just look at some topics that I've got. And first of all, as we're mentioning with regard to LinkedIn, the new TA forms continue to cause problems and issues. The word I'm getting from the Law Society is, again, a reluctance to back off, as it were, with regard to the revised TA6 forms. And what I wanted to do is to share with you my concerns. If I start by looking at some case law and assessing what I think a conveyancer ought to be saying to a seller client, if we start with that, and then we have a look at what the revised TA6 form does, I think you will see the problem that I've identified. I haven't, to be brutally honest, had an awful look at part 1 of the TA6 form, other than to say to myself, as a conveyancer, when I see the TA6 form from the client, I will have to check what the seller has said, check that against what they're saying in part 2, and check that against what I have on my file. But what I'm really interested is William Sindel PLC against Cambridgeshire County Council and Rosser and Pacifico, the recent case. And what I've got, I think, is a situation where the courts have said, if a seller is going to respond to a question, then it's implied that the seller has undertaken reasonable investigations before answering the question. So in the Sindel case, remember, the legalistic reply in the court said, in those circumstances, in order to give that reply, we'll assume that you undertook reasonable investigations with regard to the planning issues before answering the question. Rosser and Pacifico 2023 decision, the judge says, if you're saying you're not aware of any breaches of planning or building regs, there is an expectation that you checked before you gave the answer. So if that's my starting point, right, what happens where in the revised TA6, there's reference in the question to the fact that the client can seek guidance from websites or guidance from you as a conveyancer. If they haven't sought that guidance, then could a judge turn around and say, well, if your response is defective, in considering whether or not it amounts to a misrepresentation, I will take into account whether you heeded the advice or guidance on the form to research the website or to go to the Coal Authority website or whatever it is. So I think as a consequence of that, where there is guidance that's referred to in the TA6, the client must be advised to check it out and to provide evidence that they've checked it out. That would be my concern. The other problem that I have with the TA forms is the amount of additional information that the TA forms are asking the seller to produce, and thus the amount of information that you're going to have to check on your file. And if you look at the question relating to Japanese knotweed, for example, how on earth is a client going to know about the existence of Japanese knotweed on adjoining properties? And again, given what was said in that unreported case relating to Japanese knotweed, the answer is always now going to be, I don't know. And so I think the TA6 form does a number of things. One, it creates the sort of the William Sindel, Rosser and Pacifico problem. What would a reasonable client do when faced with a question where they are told that there is guidance available? I think they have to be told to go to that guidance. And if they fail to do so and provide a response that could amount to a misrepresentation, I think that failure to refer to the guidance would be detrimental to their defence. That's point number one. Point number two, the revised TA6 will require more time and thus more cost to be incurred by you in checking what the seller is saying. 3, I think you've got to change your retainer so the client understands that you will not be responsible for any reply that they give, particularly where they are told to seek guidance from a third party or seek guidance from you and they've failed to do so. In addition to that, I think you also say in the retainer that all you can do, and emphasize this point, is check what they're saying against any information that you hold on your file, and to make sure the client understands what information you have on your file, which is going to be the title deeds, estate agent's particulars, and any other information that's been produced to you by the seller. So I think you've got to be cute in the retainer about telling the client that you're not going to be liable for any potential misrepresentation. Zara says, yeah, the criminal liability point is another thing. Section 2 of the Fraud Act, in essence, states that any fraudulent misrepresentation is automatically a criminal offence. But then the guidance also generates, the TA6 generates criminal liability with regard to the failure to provide information. The other point to note, Zara, is there is also the potential for breaches of the consumer regulations as a solicitor or conveyancer. If you're allowing a seller to say something in a TA form which is incorrect, there's also breaches of the consumer regulations. I've done a few webinars on this. I'm doing another one, I think, on the TA forms on Thursday, if anyone's interested. I think that's with TM Group, but I've done them for most of the search companies, and they're all available on the search company's websites. If anyone can't access them, I've got notes that accompany the webinars that I'm happy to provide for people. Okay, next thing, Building Safety Act. I don't know where I'm going to begin with this one. I had a meeting last Friday with the Department of Levelling Up because I was concerned why the government had introduced a requirement for a landlord to produce a landlord certificate. Remember, originally there were 4 triggers for the production of a landlord certificate. Leaseholder asking for one in a relevant building. 2, leaseholder notifying landlord of intention to sell. 3, landlord including remediation costs for relevant defects within service charge. Or 4, landlord undertaking work which would lead to remediation costs which could be transmitted into service charge. Remember, the 5th one was introduced in October, and that one said a landlord certificate is required to be produced where a landlord receives a new leaseholder deed of certificate that contains new information. Is everyone familiar with that? So I have been racking my brain trying to think of what circumstances would arise where a leaseholder would produce a leaseholder deed of certificate that contained information that a landlord didn't already have. And in my stupidity, I thought it could only be where a leaseholder becomes aware of remediation work that needs to be done to the building that the landlord isn't aware of. So that was the only circumstance I could see this arising. So I rang up the Department of Levelling Up, had this meeting with them, very helpful, and I said, look, why on earth have you specifically introduced this trigger for a new landlord certificate? And what I was told staggered me. I was told that a leaseholder could issue a leaseholder deed of certificate after a landlord had requested a leaseholder deed of certificate and where the leaseholder had failed to produce it within time. Now, let me just take a step back for a moment. The Building Safety Act and the regulations enable a landlord, having received notification of a seller's intention to sell a flat or apartment in a relevant building, to demand that the leaseholder serves a leaseholder deed of certificate. The leaseholder has 8 weeks to produce it, which can be extended by a further 4 weeks on request. So a leaseholder has up to 8 weeks or up to 12 weeks to produce a leaseholder deed of certificate. Everyone with me so far? If you look at the regulations, the landlord has to do loads of different things to warn the leaseholder about the clock ticking. Department of Levelling Up says if as a leaseholder you get a demand for a leaseholder deed of certificate and you don't produce it in 12 weeks, the lease is deemed to be or assumed to be a non-qualifying lease. Now that's the stance that I've taken and the stance that everyone else has taken, it seems to me. Some, including me, have then maintained, well, the leaseholder deed, the lease is therefore a non-qualifying lease indefinitely. That's wrong. What government has said to me, the government department said to me is, if you haven't served a leaseholder deed of certificate in the 12-week period, it is assumed to be non-qualifying. But that assumption is immediately rebutted where a leaseholder serves a leaseholder deed of certificate that says the lease is qualifying. So I've had to scurry about and change my advice and change some of the guidance notes I've done, because what I'm now saying, and I'm waiting for government to come back on this, is that where a landlord requests a leaseholder deed of certificate and a leaseholder fails to produce it within 8 weeks or 12 weeks as prescribed, the lease is assumed to be non-qualifying. But that assumption can be rebutted immediately. Any leaseholder serves on the landlord a leaseholder deed of certificate that confirms this is a qualifying lease. So it's important that you're aware of that point. Next point with regard to the Building Safety Act is a question that was put to me. What happens with regard to a request for a leaseholder, for a landlord certificate, or a landlord requesting a leaseholder deed of certificate where the landlord, the building owner, has completed the purchase of the reversionary interest or of the building, but it hasn't been registered? Now, I've been looking at this, and it seems to me that there are two lines of case law. One line says you have, as a landlord, an equitable interest, and you are the de facto landlord, so you can deal with landlord and tenant issues. Now, that line of case law, it seems to me, is case law that is commercial property related. What's the position in connection with a residential leasehold management issue? And I think here, if you look at the Building Safety Act, you've got to say the Act is primarily designed to protect leaseholders. So I think in those circumstances, what a leaseholder should do, where they are not aware of the reversion being sold, is serve the leaseholder deed of certificate or notify the landlord as per the lease of the intention to sell. Only where they are actually notified that the landlord has completed the purchase of the building but not registered it, should the notification of the intention to sell or the request for a landlord certificate be made to the buyer. Last thing to talk about before we leave the BSA, thank goodness, is this issue that again continues to haunt me. If you look at the regs and the Act, they both refer to excluded buildings for the purposes of a relevant building and the protection of Schedule 8. But, and I forget which way round it is, in the regs it refers to leaseholders, and in the Act I think it refers to leaseholder. So I've had two occasions now where one occasion a building of 100 flats, one of the leaseholders owns the freehold, and therefore none of the leaseholders are protected under Schedule 8. In the other block, I think there's 70 leaseholders in exactly the same position. And in the 100 leaseholder block, the leaseholders are going bananas about the fact that they are not protected. And they're wanting to apply to first-tier tribunal for a declaration that the Act applies to them. So just watch out for that. It's important. Next thing to talk about, upfront information and estate agents. What's everybody's view about this? As far as the provision of upfront information, how's it, Zara, it's not going to happen. Is that a definite, Zara? Or is that wishful thinking? So you're just saying estate agents are just not bothering and just take the hit. What about everybody else? I've worked on Zara's theory, really, to be honest with you. I haven't had the time to give it my full attention. And I keep thinking, well, when I know it's definitely becoming active, I'll spend a bit of time. But so far, I've taken a sort of maintaining a watching brief. Yeah, all right. Thanks, Harriet. Jolly good. I like it. Yeah, fantastic. Yeah, I hope not. I hope not.
Hi, Ian.
Hi, Zoe. Yeah, hi.
Chop in there. Yeah, so what I'm being told by agents on the ground is that it's not, it's not practical.
Yeah.
National trading standards don't actually have the manpower to enforce this.
Yeah.
And so what's going on, I don't know if you saw the circus last week at Parliament. I must remember to send you guys a link.
Thank you.
So basically the chair of the Conveyancing Association was basically telling everyone that referral fee arrangements are a good thing because it means that they will have service level agreements set up. And of course, we all know that's not the case because those arrangements send work to the factory outfits.
Yeah.
But so what they're trying to do is basically shove everybody onto this one platform, supposedly sharing information, getting one source of AML, ID, source of funds. So they're trying to do all of that. But I'm saying to them, can you answer my question as to who is going to be liable? So by the Law Society combining the material information into the TA6, they've now exposed our solicitors to additional liability. So what they need to do is separate it out. A lot of the questions on there where they've put links, the estate agents could be doing that, not the sellers. And local agents would have that knowledge anyway.
Yes, true. Good point.
So, why, we're already subject to the CPRs. Which could end up with us going to prison for 2 years. And we'd also lose our license as well.
Yes.
So we won't be able to practice anymore. Why would we open ourselves up to this incredible risk?
Yeah, it's a good point. Yeah, you're right. I agree. Thanks for that, Zara. Sheila mentions some estate agents don't know about. Yeah, I agree with that. Now, why is that? Do we think the National Association of Estate Agents, the RICS, isn't sort of getting the message across or isn't banging the drum? Or do you think that they just don't want to know? I mean, from a conveyancing perspective, I was talking to someone last week and they were saying, look, we've got the Building Safety Act still unresolved, which we're worried about, which I understand. And I've just, as I say, every time I look at the Act or have a deep dive into the Act, I find more and more problems, right? We've then got the new protocols for exchanging contracts. We've got the revised TA7 form in January, which I think people still haven't got to come to terms with. Then we've got the revised TA6 form, and a bit of bad news for you, which I was going to share. The detailed Law Society guidance on climate change for conveyancers is due out. I've been asked to do some work on it. And I think the person I was talking to was saying it may be launched in June. So, I mean, there's a question of how much more a conveyancer can take, because in addition to all of this, at the end of the day, we've got a job to do, haven't we? Yeah, and well, Mark, I agree. You know, all of these professional bodies, in my view, only work when they work together. Because if not, if you've got these disparate organizations, you know, at some point to make things work, they've got to work together. So I would prefer it if, you know, the Law Society consult before throwing things into the mix, and other bodies, as I say, even though, you know, it's perfectly reasonable to think that you might take the pip with the Law Society for what they've done, trying to work together and trying to get something sorted out. If not, then I see sort of mayhem. So, Mark, thanks for that point. It's an interesting one. And Zara, yeah, write to the Law Society representatives to try and get some sense. But the feeling I get from the Law Society is that once it's out there, they won't withdraw it. They won't sort of back off, which I think is unfortunate. And again, I have three issues. One, why haven't other professional bodies been involved and participated? Two, I think as far as the TA6 forms are concerned, we need a radical overhaul of what the form is meant to do. You can't have complex questions left to a seller to complete. You can't have conveyancers thinking my role isn't to assist the client and then the client being told talk to your lawyer so that you get assistance from the lawyer. It just doesn't make sense. Harriet, this thing about a central platform or one platform information, I think again is useful. I've been a great believer for years now in having some form of central hub. So all these organizations, all these companies that come up with ideas, have to filter everything into that hub. That hub then ensures that all other software systems, etc., can talk to it and work together. And the land registry, the obvious people to do that, but the land registry don't have the appetite nor the resources to do it. Right. Yeah, I agree, Harriet, about estate agents. And yeah, really, what the Law Society is trying to push things through too quickly. In the good old days, what they would do is they would consult for a long time, create working groups, etc., pilot schemes to see how they work and let people look at what's being proposed before it's implemented. And that, all right, meant that they couldn't pivot quickly, but it meant that, you know, lawyers weren't shocked by what was being introduced, and we were getting the best. If all right, on occasions a bad job, but we're getting the best out of things. At the moment, I think this rush to get things done is a rush to the bottom. That's my view. But again, I'm willing to listen to other opinions. And I don't, you know, it seems to me that all of these ideas, you know, could do with the likes of Harriet and Zara sitting down with the committee and saying, well, yeah, I'm the person that's going to have to be dealing with this, and I've got issues or I've got problems. It seems to me that, you know, the practicalities of doing what's being proposed aren't thought about. Yeah, yeah, I agree, Harriet. Yeah, again, Parliament worries me on the basis that, you know, it's again this rush, you know, consumers need to be protected, consumers need to get better value. We need to make sure that the housing market has this fluidity, etc. We need to protect the vulnerable, you know, the people living in high-rise flats, etc. And we come up with something that just doesn't work, can't work. And therefore, what do? If we look at the BSA, we had a market that was stalling or stalled because of Grenfell, and all we've done is replaced that stalling with a stalling because people are still terrified about the Building Safety Act. Anyway, moving on if I can. Thanks for that, Zara, by the way. That's the link to the event. I'm going to take a picture of that and have a look at it when I've got time. Excuse me. Oh, thank you. That's great. If you would, Zara. Drainage issues in residential conveyancing. Just listening to what James had to say, I was impressed with James' data and also staggered about his data relating to the number of properties that are affected. But I can tell you from bitter experience, and I like your joke, Christopher, about the Brontes. Yeah, getting it right with regard to drainage, septic tanks, etc., is so important. Not just checking that there is a septic tank, that the overflow system is working and is compliant, but things like if the tank is on land that doesn't belong to you, if the overflow is on land that doesn't belong to you, ensuring that your client has the appropriate rights of access and the right to undertake repair and maintenance, I think is so important. Last thing that I wanted to mention was this point about climate change. The Law Society's guidance on climate change, and I had a long discussion about this last week, I think misses the mark. It, in essence, is saying to practitioners, you need to get training on climate change. And I think that's the last thing in the world, unless you're an environmental lawyer, that you need training on. As a conveyancer, I think you should look at climate change as you do as environmental issues or issues with regard to drainage, as James was mentioning, to know that there are risks and to know that the client can go to the likes of James in connection with risk relating to drainage or issues with regard to oil storage tanks or whatever it might be. Okay. The thing is with climate change, we need to be aware of it, obviously. We then need to make sure that clients are aware of it, obviously. We therefore draw to the client's attention the fact that we can obtain a climate change report for them, but that we can't advise on it. All we can say to the client is the report provider carries the expertise that enables you to seek that instance. That's the thing, I think, with regard to climate change. Now, what I hope the guidance does is highlight the fact that as a conveyancer, we're not in a position to give advice, that we are in a position to advise a client that a report can be obtained, and that we are in a position to recommend that the client speaks to the report or contacts the report provider for additional assistance and guidance. Now, I just want to deal with some issues. First of all, Sam raises a point. Could I run through the points again to include in the client letter? Read the TA6, please. Yeah, Sam. With regard to the TA6 form, what I'm saying is you say to the client, one, you're answering the questions. The answers to the questions are yours, not mine. If your response to a question is defective, you could be liable for misrepresentation. If you make a deliberate lie with regard to a statement, then not only are you liable for fraudulent misrepresentation, which could lead to the contract that's been entered into being rescinded, but you also commit a criminal offence. The criminal offence being committed whether the buyer proceeds to purchase or not, and whether the buyer relies on what you say or not. I think in the TA6 form, you've got to tell the client that the form requires you to seek guidance. Therefore, we will assume that you've heeded that guidance in providing a response. A failure to seek the guidance could leave you more vulnerable to a claim for misrepresentation. I think, Sam, you also say to the client, where you're seeking guidance from me, and I haven't thought this through yet, Sam, but I think what you say is that you limit liability, so that or you ensure that what you're saying to the client is put in writing, What you don't want is a client ringing you up and saying, oh, I've been told in the TA6 form, there's a question about restrictive covenants. Can you tell me what they are or what I need to know? I'm worried about you getting an email or a telephone call from the client and answering on the hoof. You can't do that. You know, you'd have to provide a formal written response. And the point there, Sam, is you'd have to charge for it. Sam, I've given some guidance on the TA7 form and some notes relating to it. And I'm currently working on the TA6 form and guidance and how you deal with it, which I haven't finished, sort of halfway through. So it's going to take me another week or so to get that finished. When it is, I'll share that with everyone. Sam, ping me an email if you like, and I'll put you on the list for that document. And anyone else, just send me an email. You've got my address, hopefully. If not, I'll put in the chat box. Also, if you want, I'm doing some additional work on the Building Safety Act, those points I mentioned earlier. Happy to share those with you as well. Right, Christy, South Hams, private drainage is rampant. Yeah. You've got to watch your lender's instructions. Very important, Christy, and watch your lenders, because some lenders will change their instructions. I think it's the interesting point there was, as James was saying, you know, how few sellers actually deal with it. And that's a point, isn't it, with regard to the TA forms, which I was going to mention at the end of James's presentation. If you're aware of a septic tank or a private water supply, etc., I think you've got to be careful how you answer the TA forms. And it might be that it's necessary to get a report from James and just to provide the buyer with that, rather than second guessing answers relating to a water supply or a septic tank. So I think the additional, and I haven't looked at the drainage and septic tank questions on the revised TA6 yet, but I think given where we're going with that, it's probably worth advising a seller to get a report from us and a specialist such as James before answering the questions. Okay, that's my topics for the day. Once again, I'm sorry to have sort of burdened you with all of this. If anyone has any other questions or any topics that you'd like to talk about, let me know. Did you find James interesting? He's a really nice guy, to be honest with you. Thanks, Zara. Right, that's interesting. Yeah, I thought the Law Society weren't responding directly, so thank you for that. Any other topics that you'd like to talk about, or topics for next time? Yeah, he's good, isn't he, on LinkedIn? He's a great guy, to be honest with you. I like him. Very keen to be supportive of the profession, which is always nice, isn't it? So any burning questions? I think what we'll do next time, we'll talk to Freddie and the team at Stewart Title about indemnity insurance. Sources of funds. Yeah, Jenny. Any particular part of that? And well, right, I'm just going to make a note of these. So we've got stuff for next time, haven't we? So sources of funds. Jenny, let me know what exactly you want to talk about. 4.6.4 standard conditions. We'll have a look at, Christopher. What are you talking about? Statements. Right, okay, I've got you. Yeah, Jenny, I've got that. Right. Okay. Yeah, we'll have a look at that. Might get someone to talk to you about AML as well. Might get a guest to come along in the future. Has that been useful today? I think it is. Zara, drop me a note though, and I'll have a look at the specific point you're making there. But has it been useful? Remember, you know, these are your day. They're not. It's not me. It's not the Ian Quayle Show. Far from it. So what I want is topics, or if you want speakers to come along. I am, Rachel, Christy, everybody else getting really positive response, but that's fine. I'm going to leave on this, right? Saying it's very useful and thank you, that's brilliant. But what I'd really like is what can we do to improve, or what can we do to give more value? So please drop me a note by email with what else we can do for these topics. I am now seriously thinking about a Building Safety Act forum. I think that's where we're going to have to go with it, because the problems and the issues aren't going away, and therefore I think a specialist forum for that might work. But on that happy note, ladies and gentlemen, thank you very much. There are more firms taking on the work. Freddie, the team at Stewart Title, as ever, a massive thank you to you for organising this event. It's really appreciated that you invite me along. Thanks everyone for your time. Speak soon. Joanne, lovely to hear from you. Kerry, great. Sue, as ever, brilliant. 464 in the future. Okay, we'll have a look at that, Christopher. Okay, and we'll talk about that next time. Thanks everyone. Stay safe and speak soon. Bye-bye.